He explained that the intent was to allow any ballots received within the period, even whether they were not postmarked or the postmark was ineligible. We need not inquire into the legislative intent. As I said, they go into legislative intent when they want to manipulate things. Oh, we don't know what they meant. Yeah, you do. The law is clear and unambiguous. A mail ballot must contain a postmark, and therefore any inquiry into the legislature's intent, whatever they were talking about, is erroneous. No one cares. What they wrote is what matters. Late ballots will be counted in Nevada. That's according to the state Supreme Court, and this is very curious because we know there was another decision from the Fifth Circuit that said that ballots in Mississippi and Texas and elsewhere are counted on election day. If it comes in after the fact, those do not count. Why? Well, because there's a lot of constitutional precedent that explains why we need it on a particular day. It's in the law, it's in the statutes. Having it on one day makes it final. You don't give an opportunity to end the game and then have one team just taking shots on goal after the game is over, which is what the Democrats would like to do. So what has happened here is that the court has come down and they said, now get this, there have been other situations where the courts will say, well, as long as it was in the mail before the election ended, then it's good. So as long as you dropped it off like the day before, then the election happens, then your ballot gets delivered the day after the election, like, okay, that's good in some locations. But now, no, doesn't even matter. Doesn't even have to be postmarked. If it's unpostmarked and it gets delivered 3 days after, not even in the mail, just shows up, it's good to go. Well done, Nevada. But here is what it says. It says the Nevada Supreme Court will allow state officials to count absentee ballots that arrive without a postmark as many as 3 days after the November 5th general election, rejecting a challenge brought by the Republican Party. So the Republicans say, no, you have to stop counting on election day. It's over. The decision on Monday is a setback for the national GOP and a big victory for Democrats who want to just flood the zone with extra votes. A majority of the Nevada High Court found that a state law allowing mail-in ballots to be counted, if the postmark date cannot be determined, applied to envelopes with no postmark at all. What if it doesn't have a postmark? No, it's fine. Court said it's fine. Republicans had said the law should only cover ballots where postmarks aren't legible. Well, if you can't see it, like if it's postmarked and it's like, well, I don't know what the hell that says, but at least it's a date, then you count that. But if it's no postmark at all, that now counts. It wasn't immediately clear how many ballots might be affected. The GOP offered an example of 24 ballots that were received by one county during this year's primary. But the case is part of a broader effort by Republicans, they say, to impose more restrictions on absentee voting and question the security of the process, which is a total disaster, as we know. But the case is part of a broader effort by Republicans to impose more restrictions on the voting. Now, a spokesman for the Republican Party didn't respond to a comment. Nevada justices wrote in their opinion the following. Let's get to it. As you can see, it was the Republican National Committee and Donald Trump for president and the Nevada Republican Party versus the Nevada Secretary of State. And what you'll see here is the Nevada Alliance for Retired Americans. Anybody having 2020 flashbacks? Yeah, because that's what we saw all over the place. The Michigan Alliance for Retired Americans, Nevada Alliance for Retired Americans. These were the groups that we saw in 2020. They were all filing lawsuits against the secretaries. They would settle the claims, change the rules, enter into a contract, call it a settlement agreement, and then say that the state was bound by the settlement agreement, even though all of that was outside the law. Then the Republicans sue and say, you can't do that. You can't just interpret things to accept everything whenever you want from anybody you want. So here's what the Supreme Court says. Highest court in the land there says, this is an appeal from the district court denying injunctive relief in an election matter. Now, the Secretary of State's office, they tell us, through testimony to the legislature and a memorandum circulated to election officials, has interpreted this statute or this rule such that a mailed ballot without a postmark that is received by 5 p.m. on the third day must be counted. So the law says something. He says, the secretary says, well, yeah, my interpretation of that is I can take these ballots that late. RNC, Trump, Scott Johnson, they call them the RNC, bundling them together. They sued. They want an injunction. They say you have to stop these officials. Stop them from counting the mail-in ballots without a postmark that are received after the general election if they just print a bunch and ship them in. The district court granted a motion to intervene by Nevada and the retired Americans. The state opposed the motion. They want to count the votes. After a hearing, the district court denied the motion and they now appeal. So they talk about standing, first of all. Of course, that's where we go. They say the RNC argues that it has standing under resource diversion and competitive injury standing theories. And so we're going to review this to see if that's true. We must first conclude that the RNC did not demonstrate standing under a resource diversion theory, saying the RNC says that it currently expends a lot of resources on election monitoring. We have to keep our eyes on these things, but it would need to expend additional resources to specifically monitor mail-in ballots that come in without postmarks. So we're going to have to invest a lot into this if you count these. But they say the RNC already monitors the elections, okay? So you're already going to have people there. So don't act like it's going to be a bunch of additional work, okay? You're already there. Accordingly, any additional resources would just be ongoing or business as usual. And so that's not enough for standing, meaning you're not harmed by having to do this. You're already there. Nor did the RNC allege that the challenged action affects their core business. And so the RNC lacks standing under that theory. So let's talk about the next one, competitive injury standing. They say, well, this one is also strained. It presents a closer call at this stage, telling us, assuming without deciding that the RNC has demonstrated competitive injury standing, we'll say they do have standing, we nevertheless affirm the order denying the motion on the merits. So regardless of standing, we'll say maybe you do, maybe you don't, but we'll say you do, and we'll just address it. Now, a preliminary injunction, which is an order from the court, in this case, it would be an order from this high court telling the election officials, if they come in after the election, you cannot count them if they're not postmarked. So they say, okay, we have to review this. Now, this court reviews this for an abuse of discretion. Did the lower court screw up? They say the Republicans argue that it demonstrated a likelihood of success. Why? Well, they say, first of all, we're likely to succeed on this. In fact, the law says you cannot count the ballots received 3 days after election day that are not postmarked. And second, the RNC also argues that it was likely to succeed on its argument that the memo violated the notice requirements, right? So then the secretary comes out, he says, well, this is how I'm interpreting this. So he should give people notice so they can contest that, file lawsuits and other things before he takes action. So they tell us what the law says. In Nevada, the revised statutes provides, quote, if a mail ballot is received by mail not later than 5 p.m. on the third day following the election and the date of the postmark cannot be determined, the mail ballot shall be deemed to have been postmarked on or before the day of the election. So that's the law. Now, this court is reviewing this. They look at the plain language of the statute. They say this is susceptible to two reasonable interpretations. We can say there's two things. One, which is the RNC's, is that the mail ballot must have a postmark given, because when they say when the date of the postmark cannot be determined, well, that means there was a postmark, but you just can't read it, right? That's what it means. It's there, but you can't determine it. Now, under this interpretation, subsection 2 applies only where the ballot has a postmark, meaning you only accept it when the postmark comes in, but you cannot determine it because it's ineligible or it's smudged. It got wiped off or something. So it's there, right? It's in the law. It says the postmark cannot be determined, not that it does not have a postmark. Now, the second interpretation, which is what the Democrats prefer, offered also by the state, is that this applies to ballots without a postmark entirely, because they say, well, if it doesn't have a postmark, guess what? Well, then you cannot determine the date. So yeah, obviously you can't determine the date because there's no date on there. So cannot be determined. Now, the federal district court interpreted this, concluding that it established, the bigger concept was, it says it establishes a presumption that a ballot was cast in time as long as it's received by election officials before 5 p.m. on the third day after the election, even if it lacks a postmark. So what they're doing now is they're going to federal courts. So they say in this case, this is a federal court that said, well, something very similar issue, maybe not the same law, but a similar issue. And while our dissenting colleagues note, as we're going to see the other court dissenters are unhappy about this, they say that the legislature could have clearly stated that it intended for subsection 2 to apply for ballots without postmarks, but the converse is true also, meaning if they wanted it to count ballots that don't have any date at all, they would have said it. But they say, well, they could have also said that they could have said only applies to ineligible or smudged postmarks, so they could have been more specific the opposite way too. Now, because the statute could therefore reasonably be interpreted in two ways, we're going to look to the legislative intent. What did they intend to do? And this is where things get slippery, because then the court just substitute their intentions for the legislatures. Now, the legislative history is consistent with the interpretation proffered by the Democrats. For example, during a hearing on the bill, one assemblyman and the bill's sponsor was asking about the postmark cannot be determined provision. He says, I'm wondering why you believe it's good policy for us to accept mail ballots where the postmark date cannot be determined. And I'm wondering if we know how often that happens and where a ballot comes back without a postmark date. So they looked at the meetings and they look at the record and they say, he said without, which means cannot be determined. It's the same thing. So in response, he explained that the intent was to allow any ballots received within the period, even whether they were not postmarked or the postmark was ineligible. And so they're literally talking about what these guys were talking about at the debate. During a later meeting before the Nevada Senate Committee on Finance, Frierson also touched on the broader purpose of the bill and saying that we conclude that the legislative history history supports an interpretation that anything without a postmark will be counted. They also say public policy supports this too. As explained in the legislative history, the purpose of the bill was to expand the ways in which people can vote. Of course, yeah, including after the election's over. If a voter properly and timely casts their vote by mailing their ballot on, before, or on the day of the election, and through a post office omission, the ballot is not postmarked, it would go against public policy to discount that properly cast vote. So the post office is failing. Got it. So it's not that you're not getting it in the mail, it's that the post office is not postmarking it. Indeed, there is no principal distinction between mail ballots where the postmark is ineligible or smudged and those with no postmark at all. In each instance, the date the mail ballot was received cannot be determined. So it's the same thing. Well, one is making sure that it actually was going through the postal service, right? That's the purpose. The legislature has accounted for difficulties in determining the date. The point is that it's in the mail. It's not being developed after the fact. It's a contemporaneous stamp that if something was chronicled, you did it. We also conclude the RNC's argument that it's within the voters' control to ensure that their ballots are postmarked is insufficient. There's strong public policy here. We have to win elections. The RNC asserts that a voter can ensure their ballot is postmarked by visiting a post office and requesting it. While this may be possible for some voters, it's not possible for everybody, and the statute doesn't impose that burden on them anyways. And so the RNC is, like as demonstrated, they're going to fail here. And so the RNC also argues that the district court made a mistake by saying they didn't give us proper notice of these changes. But the RNC saying that Republican voters voting by mail at a much lower percentage than Democrat voters, and so thus counting invalid mail ballots after Election Day would benefit Democrats at the expense of Republicans. Now, the RNC's complaint identifies various sources supporting its assertion that the partisan lean of mail ballots would favor Democrats, but the RNC did not present evidence as to the partisan lean of mail ballots that don't have a postmark. So the Republicans are saying this is going to benefit them if you let them have 3 extra days of mail-in balloting. You understand? Because that's what they do. So they can just deliver a bunch of stuff in the mail. I said, well, so what? You have to show that it's biased because you don't have a sample of all the ones without a postmark. And it's like evidentiary problem. It further failed to present evidence that the 24 mail ballots received in Clark County after Election Day without a postmark impacted any race. Okay, so it's no widespread fraud that impacted the outcome or that it would impact the outcome of 2024. So the RNC also fails to demonstrate a potential hardship on anybody. And so thus, because the RNC fails, we believe that the lower court did not err. And so ballots can come in even without a date in Nevada. So incredible. Signed by these 5 judges who, sure, they have got interesting backgrounds and records, but here is the rest of the decision. This guy is concurring. He says, I concur only insofar as I agree that they've made an insufficient showing that there will be irreparable harm. But I disagree that this allows for the consideration and the counting of mail-in ballots after election when they don't have a postmark. This is unambiguous, and so we need to look no further than the text itself, he says. When a statute is facially clear, we don't need to go beyond it, like this court did here. In Section 1, the statute is clear. A mail ballot must contain a postmark. In order for a mail ballot to be counted for any election, the ballot must be mailed to the clerk and postmarked on or before the day of the election. It says that. It's a requirement. In Section 2, the statute allows for an exception, but still requires the existence of a postmark if a ballot is received no later than 5 p.m. on the 3rd day. If the postmark, right, it's there again, it's got to be there. It's clear. The postmark means it requires a postmark. Read together, the statute is clear, it's unambiguous, it requires the existence of a postmark. The exception cannot exist without the triggering event. In other words, a postmark cannot be indeterminable unless there is a postmark to begin with. To read otherwise contravenes the plain text of the statute. Under no reading can we omit the requirement that a postmark must exist. And so therefore, we need not inquire into the legislative intent. As I said, they go into legislative intent when they want to manipulate things. Like, well, we don't know what they meant. Yeah, you do. The majority's conclusion to the contrary runs afoul of our basic statutory construction principles. It's how we write the rules. And so we're not going to read implied terms into the statutes. The law's inclusion of a postmark requirement implies the exclusion of non-postmarked ballots. Now, if the legislature intended to include mail-in ballots that contain no postmark whatsoever, it would have done that. They could have included language allowing for an exception with an indeterminable postmark or no postmark. They could have added those 3 words in, but they didn't. Instead, the statute is clear that a mail-in ballot must contain a postmark. No mention of mail-in ballots that are void of postmark altogether even come in here. And so the majority is making a mistake erring in reading in the terms of that the legislature omitted. If we were to take the majority's view, the postmark language would be entirely unnecessary, and there would be no need for the language entirely. If the exception was meant to count mail ballots, regardless of any sort of postmark, illegible or otherwise, that met the relevant time requirement. And the mention of a postmark at all would be unneeded. That is, the language of the statute would simply accept any mail ballot that was received, even without a postmark. Just get rid of it. If you have it in custody, it's good. Don't even need to mention a postmark. But we must read the statute to actually give meaning to the phrase. And so in sum, the law is clear and unambiguous. A mail ballot must contain a postmark, and therefore any inquiry into the legislature's intent, whatever they were talking about, is erroneous. No one cares. What they wrote is what matters. We must read the statute as it is written and stop reading terms into the statute that they never put in there. If they meant to include mail ballots without a postmark, as you guys say they did, it would have done it, but it didn't. And we cannot read into the statute exceptions that do not exist. Do so contravenes our simple reading interpretation abilities. And because I believe the majority errs, I respectfully concur in the result only. And his is more of a standing problem. Same here, Pickering, same thing. I join my colleagues. The parties offer competing interpretations. While I agree with Justice Herndon, the guy just above, that the statute seems to say that it must be postmarked, that is not the argument that the appellants make. Instead, they argue that while the mail-in ballots do not need a postmark, ballots that arrive in 4 days must have a postmark to be counted. Now, while this reading may have a plausible policy justification, it does not comport with the statute. They argue that while mailed ballots that arrive on or before Election Day do not need a postmark to be counted if it arrives before, ballots that arrive in the 4 days following must have a postmark. Yeah, because the postmark is relating it back to them sending it before the election ended. So we know that they ended it when they were supposed to end. They didn't vote after the fact. While this reading of the statute has a plausible policy justification, it doesn't comport with the text either. It conflicts with the Secretary's interpretation, which instructs that mailed ballots that do not have postmarks will be counted so long as they're received. He's talking about the injunction, saying, I would affirm the order denying the motion for 2 reasons. First, while I share the concern with the endorsement of the accepting ballots without postmarks, I am also not convinced that the appellant's reading is correct either. Under their interpretation, mailed ballots without postmarks that are received on or before Election Day would be counted, but those received after that date would not be counted unless they have postmarks. This is a distinction that they do not make, that the law does not make. Okay, that might be true. Our rules of statutory interpretation require adherence to that, absent ambiguity, which doesn't appear here. Second, and more importantly, it would not be in the public interest for the court to reverse that. Mailed ballots are already sent to voters. Voting's already underway. Court orders affecting elections are problematic. It's not in the public interest to change things this close to the election, and for this reason, while I disagree, I concur in the decision with the holding, signed by Pickering. We'll keep our eye on it, my friends. Thanks for subscribing and joining as we do.